Good morning, this is your Kelso Report for Thursday, May 17th, and I'm your host, Clark Kelso. Our cases today include searches and seizures of automobiles, guilty pleas, employment discrimination, revenue and taxation, and labor law. We begin with a Ninth Circuit case involving the law of search and seizure, this time in the context of an automobile search. The propriety of an inventory search of a car after the car had been impounded subsequent to the driver's proper arrest for driving without a license was before the Ninth Circuit in United States v. Cervantes. Now, the law is clear that following a driver's arrest, and where there are no passengers who can drive the car away, the police may impound a vehicle as part of its community caretaker function if the vehicle poses a danger to traffic or would be a target for theft or vandalism if left on the street. Once impounded, the police may conduct a regular inventory search. That type of search in Cervantes revealed 2 pounds of cocaine in a box, evidence which the defendant sought to suppress. By a 2-to-1 vote, the majority of a Ninth Circuit panel held that the prosecution failed to put on sufficient evidence, establishing either that the car was a traffic hazard where it was parked, or that it was peculiarly susceptible to theft or vandalism. Absent such positive evidence, there was no basis for impounding the car. For the dissent, the facts of the case fit the community caretaker function perfectly, so the majority's failure to approve the impoundment and inventory search is a complete mystery that will now confuse law enforcement agencies throughout the Ninth Circuit's geographic jurisdiction. I think the dissent probably overstates the problem just slightly. What we clearly will see in the next case involving these doctrines is how much additional evidence must be introduced to satisfy the new standard. The majority opinion creates some minor confusion right now, but I think that confusion will be reduced pretty quickly as prosecutors figure out how much more evidence they need. Now to the California Court of Appeal. The defendant in People v. Breslin pled guilty to 1 count of corporal injury to a spouse or cohabitant. After the defendant pled guilty, the victim disclosed that he had wanted to recant his testimony shortly after the defendant had been arrested, but he just couldn't find anyone to talk to at the district attorney's office. Based on this disclosure, the defendant then made a motion to withdraw her guilty plea, alleging mistake and ineffective assistance of counsel in failing to discover the victim had tried to recant his testimony. The First District rejected the defendant's arguments. On the issue of mistake, the court held that the late disclosure by the victim, which came just before sentencing, did not constitute convincing evidence that the guilty plea was the result of mistake, ignorance, or inadvertence. And the court also rejected the ineffective assistance of counsel claim. There's a healthy dose of skepticism about the entire claim of an attempt to recant, not surprisingly. Our next case involves employment discrimination. An interesting legal question is whether a partnership can be held liable for discriminating against one of its own partners under California's Fair Employment and Housing Act, since the act appears to apply only to discriminatory acts by an employer against an employee, and a partner is not an employee of a partnership. But that was not actually the question presented with the plaintiff's complaint in Fitzsimmons v. California Emergency Physicians Medical Group, which the Superior Court incorrectly dismissed. The issue in Fitzsimmons was whether an employer that happened to be a partnership could be held liable for retaliating against a partner who opposed discriminatory acts by the partnership directed at one or more of the partnership's employees. And according to the First District, a retaliation claim was permissible, since the statutory language creating that cause of action did so in favor of, quote, any person, close quote, which the court held was not limited to employees. Next, a revenue and taxation case of interest to those of you who own mobile homes. When a space in a resident mobile home park is sold, the question that can arise, how to assess the value of what was sold. In Section 62.1 of the Revenue and Tax Code, the legislature decided that the value should be assessed as the, quote, pro rata portion of the real property of the park, close quote, which is further defined as the total real property of the mobile home park multiplied by a fraction consisting of the number of shares of voting stock transferred divided by the total number of outstanding issued or unissued shares of voting stock in the entity which acquired the park. In reassessing transfers of ownership occurring in 2001 in 2 tenant-owned mobile home parks, the assessor for the County of Santa Barbara relied on a letter opinion issued by the State Board of Equalization and arrived at the value of the space underlying the mobile home simply by subtracting the purchase price of the mobile home from the mobile home's value as established by an authorized valuation manual. Well, in Assessor for County of Santa Barbara versus Assessment Appeals Board, over a spirited dissent, a majority of the 2nd District rejected the Board of Equalization's letter as clearly inconsistent with the statutory assessment method. And there's really no question that the two things were inconsistent and the statute prevailed. Next, pursuant to his guilty plea, the defendant in People v. Shoker was convicted in 2005 of possessing marijuana for sale, which is a deportable offense. The change of plea form he initialed, signed, and declared he read advised defendant of the immigration consequences of the conviction, namely that he would be deported. The court also advised defendant of the immigration consequences of a guilty plea, a fact the defendant did not contest. So, 7 years later, after defendant successfully completed probation, after he successfully had his guilty plea withdrawn, a not guilty plea entered, and the case dismissed pursuant to Penal Code Section 1203.4, immigration removal proceedings were begun by the federal government. And the defendant then brought what he styled a non-statutory motion to set aside his conviction based on counsel's alleged ineffectiveness for not explaining the immigration consequences of his guilty plea. The defendant recognized that he did not qualify for relief under habeas corpus or error coram nobis. The defendant argued, nevertheless, the non-statutory motion was required by the United States Supreme Court's opinion in Padilla v. Kentucky. Well, the 4th District correctly rejected this argument. The Supreme Court in Padilla recognized that failure properly to advise a defendant about the immigration consequences of a conviction can indeed constitute ineffective assistance of counsel. But it did not hold that states had to create new procedures as a safety net to provide a remedy when other remedies through which relief might have been obtained are no longer available because of procedural default. Finally, we have a labor law decision involving successor liability. In People ex rel. Harris versus Sunset Car Wash, the 2nd District strictly applied the 4 circumstances under Labor Code Section 2050 that established successor liability for unpaid wages and penalties owed by a predecessor employer who operates a car wash. Section 2050 was enacted by the legislature to deal with the particular concern that car wash employees were not being paid in accordance with law. One of the triggers for successor liability under the statute is whether the business uses substantially the same facilities or workforce to offer substantially the same services as the predecessor employer. The defendant tried to add additional factors to this definition from case law dealing with other situations. But the 2nd District correctly stuck to the language in the statute and rejected the invitation to look elsewhere for further definitions of successor liability. And that's it for today's Kelso Report. Have a great day in the law.